Hello and welcome back to the One Take Show. On 24th of April, India got its new Chief Justice. Honorable Justice N.V. Ramana sworn in as the 48th Chief Justice of India. Let's look at a couple of facts about him and some important judgments that he propounded throughout his career in this episode. Honorable Justice N.V. Ramana sworn in as the 48th Chief Justice of India on 24th of April 2021, and he is set to retire on 26th of August 2022. Justice Ramana was born on 27th of August 1957 in the village of Ponnavaram in Andhra Pradesh, which makes him the first Chief Justice of India from Andhra Pradesh, and he was enrolled in the bar as the advocate on 10th of February 1983. The most interesting fact about this is that he is actually a first-generation lawyer who has made it to Chief Justice of India, an incredible source of inspiration for any law student or any lawyer like me, perhaps, who's going to become a first-generation lawyer, to learn from his experience and look up to, especially in times like this when the market is changing so fast and the opportunities are dwindling down. So it's a great opportunity for us to learn from someone like him. Justice Ramana was appointed as a permanent judge in the Andhra Pradesh High Court in 2000, and he served as the Chief Justice of Andhra Pradesh High Court for a short period of time till May 2013, and was appointed as the Chief Justice of Delhi High Court in the same year 2013. He was later appointed as a judge in the Supreme Court of India in 2014, and as a judge in Supreme Court he dealt with some of the most important cases involving issues around constitutional law, civil liberties, commercial laws, arbitration and election, etc. Although Honorable Justice Ramana has written about 157 judgments so far, we'll look at a couple of those landmark judgments that really define his career so far. In the case of Anuradha Bhasin versus Union of India, Honorable Justice Ramana led a bench that heard the petition against the curbing of internet in the state of Jammu and Kashmir during the abrogation of its special status. It was held that the right to freedom of speech and expression and the right to carry out trade on internet is a fundamental right, and using the principle of proportionality, it was held that the suspension of internet cannot be carried out for the indefinite period of time. Moreover, it was instructed that the officials, for the purposes of suspension of internet, need to publicize the same with sufficient reasons involved. Moreover, the curfews that were implemented under section 144 of CRPC have to be used with reasonable prowess and reasonable restrictions, because the same cannot be used to suppress legitimate expression of grievances or protest or the freedom of speech and expression. In the case of Foundations for Media Professionals versus Jammu and Kashmir, the bench led by Justice Ramana propounded that the fundamental rights have to be balanced with the requirements of state security, and appointed a special committee to look into whether those restrictions were narrowly tailored and were not permanent in nature. In the case of Union of India versus K.A. Najib, it was propounded by a bench led by Justice Ramana that Section 43D of UAPA does not oust the power of a constitutional court to grant bail to the accused if the provisions of the fundamental right to speedy trial are being violated in a particular scenario. In the case of Kirti versus Oriental Insurance Company Limited, it was held by a bench led by Justice Ramana again that the conception that housemakers do not contribute to the economic value of a household is a problematic idea from the beginning itself, and it was held that this idea had persisted for many years and must be overcome at this stage. In the case of Ashwini Kumar Upadhyay versus Union of India, the bench led by Justice Ramana passed various orders to streamline and expedite the matters of criminal investigation which were inordinately delayed because of various reasons, and also passed various orders for the protection of the witnesses involving the criminal cases against the various politicians. In another case of accused versus State of Maharashtra, the Supreme Court held that post-conviction mental illness will be a mitigating factor for the accused that has been termed for death penalty. In the case of Srimant Balasaheb Patil versus Union of India, the judgment of Justice Ramana held that the resignation of the legislators will not efface the effect of the disqualification if the defection had already taken place before the date of resignation. In the case of Shiv Sena versus Union of India, Justice Ramana highlighted the importance of floor test to curtail the unlawful practices such as horse trading and to effectuate the smooth running of the democracy of the courts. In the case of Vidya Trolya versus Durga Trading Corporation, the Justice Ramana led bench clarified the scope of the judicial review of the courts in order to determine the validity of the arbitration agreements at the stages of Section 8 and Section 11 in the Arbitration and Conciliation Act. In the case of PUDA versus Vidya Chatal, it was held by the bench led by Justice N.V. Ramana that even services rendered by statutory authorities can be brought under the ambit of the Consumer Protection Act and can be adjudicated upon by the consumer forums. In the case of Excel Corp Care Limited versus CCI, a bench led by Justice Ramana held that the violation of the competition law would respectively cater to the formula which would calculate the penalties for the said violations. Justice Ramana held that the penalties would integrate proportionality and the constitutional virtue. The judgment authored by him provided two-step formula to calculate a turnover relatable to the product in which the anti-competitor practices were involved as well as observed. In Mansukh Bhai Kanjibhai Shah versus the state of Gujarat, it was held by the court that the officers of the deemed universities also perform public duties and henceforth are public servants under the definition of Prevention of Corruption Act. In the case of Union of India versus Dharampal, the court led by Justice Ramana held that the solitary confinement of a person sentenced to death prior to the rejection of the mercy petition is palpably illegal. Hence, ladies and gentlemen, these are the various landmark judgments by now Chief Justice of India, Honorable Justice N.V. Ramana. I would like to credit a wonderful article by Live Law that summarized and compiled all these judgments. If you like this video, please make sure you like, share and subscribe to the channel. If you have any suggestions or feedbacks, write them down in the comment section. And ladies and gentlemen, I'll see you next time.